Okay. Can you see the PowerPoint?
Yes.
Yes.
Yes. Yeah.
Okay. Okay, perfect. Good morning, everybody. Thank you for joining me here for this lecture. We're going to talk about wills and estate planning. At first, let me have a brief introduction of me. My name is Alex. Sorry.
Do you want to show just the PowerPoint and not the slides coming up? Just do full screen.
Well.
Oh, it's up to you.
Well, if it's just too small, I can do that. But like, I just prefer to have this.
Okay. Yeah.
So that I have a better control of which slide to show. So my name is Alex. I'm a lawyer here in Calgary. Licensed to practice law here in Alberta. I have lived here for several years. I love Calgary. I have a son, and my husband is IT guy. He's a pretty simple guy. And my I'm happy living here. Because we're going to talk about the wills and estate. So I assume our lovely audience do not have these wills or personal directive or power of attorney, all three legal documents we're going to talk about today, which is assume you just haven't got one yet. For me, I already had my wills and personal directive and the power of attorney done, and I would have to say that the first, the younger couples who came to my office to do the wills and then the other three documents is when they first have their when they have had their firstborn. So you'd be responsible for your children when they are not grown up yet. They need to have a guardian if something should happen to the parents. So I understand in Chinese culture, the perception of the wills and estate planning is a little bit different with the Western culture, but I always think it's a good thing to have everything planned in advance so that we can avoid a lot of trouble and difficulty for others. So a little bit introduction and a disclaimer. Today, our lecture is for general introductory information only. I'm sure you heard this a lot because we have to disclaim this in every lectures. The relationship between us is not solicitor and client relationship. It's not protected by that relationship. So no legal advice provided today. And we're not forming any solicitor-client relationship. And if you do have a legal issue, please contact a lawyer. Or if you want to ask me if it is a specific question, it's better to be asked, not during the lecture. But if it's just a general question, that should be fine. Okay. So, estate planning. I don't know what what comes into your mind when this word, when we're talking about this word, estate planning. But I do encourage you to think about the following questions, because those are very important questions when it comes to estate planning. Assume like one day will become like mentally incompetent. So competence is a really important conception, like in estate planning, because all the documents you sign, whether it's will, whether it's personal directive or power of attorney, you will have to be competent, mentally competent, to be able to sign. I mean, like to give legal effect to those documents. That's the first consideration. A second one is, well, like now we can, do our daily banking. We can, just use our credit card, whatever we want. We can pay our bills. We can, sell the house if we want to. We can give a gift to other people if that gift is like of like some significant value. Those are like, financial decisions that we're gonna make. We can buy stocks, we can sell stocks. But if we become mentally incompetent, for example, some kind of disease or accident happen, like somebody could be in a coma and cannot do any decision making stuff, or simply just like when we're getting older, the bank sometimes will refuse our instruction or certain financial matters if like our broker or the bank thinks there's a possibility that we are not mentally competent. Yeah, so those are matters you want to consider, because like one day, like we all gonna become mentally incompetent sooner or later. Well, hopefully, really in really late stage, but this is a question we have to consider. If like when that day comes, who do you think would be the best person to represent you? Well, it could be your spouse, because like, presumably like that's the most important and like the person you trust the most. But it's possible that your spouse would be older than you. Like your spouse could be older than you, so he or she could become mentally incompetent too. So like another consideration, another option would be your children. But if you have like several children, like which one would be the best? Or if your children lives abroad, like let's say if we live here in Calgary, but okay. Income, welcome. Okay. Okay. We're saying, what if like your favorite child or the child you trusted the most has his life in the United States, so he won't be as available as other people when it comes to like day-to-day decision making, or even help you do your financial matters. So that's something to consider. Okay. And then another heavy question is, who will represent me when I die? That's the question regarding the wills, because one of the most important questions to ask is, who do you want to appoint as an executor, as like kind of your representative after you die, to represent your will, to distribute your estate the way you want it, right? So you definitely want to consider whether your like certain child or certain friend or niece or nephew would be in the best position to be in that role. And another important question is regarding the guardian. It's like, who will look after my children if something happens to me? But since we're this is a lecture to the seniors, so I assume though that question wouldn't be much relevant. And who will divide my property? And what properties is there to give away? So what kind of estate will you have, like, when the day comes? And also, where is the property located? Why is that important? Let's say you have a property in Hong Kong, like, or mainland China. Well, if you like the will you do here in Alberta does not necessarily cover the foreign properties, because the estate law, is different, not just between the countries, but also between the province too. For example, here in Calgary, we don't worry too much about the inheritance tax per se, because some people ask me about, like, what kind of tax would my children have when I leave my estate to them. Here we have the lowest tax, and also we when your executor probate your estate, it's just like a couple of $100 they need to pay to the government. But in Ontario or in British Columbia, it's a totally different thing. Like, they probably would have to pay sizable amount of money to the government regarding the tax. So it's different. If all your properties are in Alberta, then that's good. You don't have to worry about too much about this stuff, about the tax, or perhaps do another will in a different province where you have other property, or have a will done by let's say Chinese lawyer, if you have real property in China or in the Philippines. Okay. So to whom will my property go? Like, who do you want to give your property to? Probably not just one person, but several peoples. Like, how do you want to distribute the properties between them? And how will I protect my spouse or partner, my children, and any other people who depend on you? How do I want to spend the last part of my life? This is regarding the personal, mostly the personal directive, which is to deal with if one person becomes mentally incompetent. Who's gonna do the day-to-day decision making for you? And in that document, you pretty much describe how you want to live your life. If you cannot make decisions for you, you want to show them like, this is how I want to live my life, right? So make the decisions according to these instructions for me. Okay, so today we're going to talk about 3 legal documents regarding the estate planning. The first one is the will. I kind of already covered this topic, but wills, like, you want to consider who represents you, who represents your estate when you die, who looks after children if you die when the children are still young, who gets your property, those kind of questions, right? And enduring power of attorney regarding the financial decisions, right? Who makes the financial decisions for you if you become mentally incompetent? And then the third one, personal directive. What do you want your life to be like? And what medical treatment would you be comfortable with if you become mentally incompetent? Okay. Why do we need to consider estate wills and estate planning? Why doing a will and engaging in this planning is important? Some of my clients ask me, like, when do you think is the best time for me to do a will? I always say, preferably like now, because you never know what happened tomorrow, right? And hiding property the wrong way, you can have serious consequence for your dependents. If something happens to, if you don't make the plan, things could get into chaos, right? If you have children, you want to make sure they are taken care of. I mean, they end up in a good, loving home. If you cannot, do it yourself. Estate planning can highlight vulnerabilities such as a lack of life insurance. And if somebody becomes mentally incompetent, your own quality of life may depend on the planning you did in advance. Or if they're like disabled dependent, you would want to consider doing the estate planning in advance so that you are making sure that they are protected. Okay, so now let's pretend we're doing a will. What roles do you want to, like, the important questions? Here are the 3 questions. Is who do you think you want to appoint as executor in your will? The definition of an executor is a person who administers the estate, applies for probate, and distributes the estate to the beneficiaries. So so think about, like, who would be the best fit to be an executor. Maybe somebody, like, you trustworthy, but maybe they are pretty like, how should I say, not messy but not organized, or irresponsible. Well, he would do anything for you, but actually he cannot handle or put his things together in his own life. So can he administer the estate? You probably want someone who has education here, or how should I say? Because we are like from Chinese background, so you probably want someone who can speak English so that they can apply for the probate like easier, because it's a process, right? Another role is guardian. That's for the minor children. Basically, you like that person is who the minor children is gonna live with after their parents died, right? And then probably the most important one, beneficiary, people who receive something from the estate. That is to say, leave your valuable stuff to whom? Who are you giving your property to? Then here are some recommendations regarding if you have multiple names in your mind regarding who should I appoint as my executor. The tips are who is like very likely a good executor looks like. The first consideration is like he or she is better not too old or nor too young. If the executor is too old, he probably has his, maybe he's not capable of handle the process. Something could happen to him. I mean, like, what if in the middle of the probate, that executor become mentally incompetent, or goes to a hospital. You never know. So if an executor appoint is too young, let's say your grandchildren, it probably is not mature enough to be responsible for the role of an executor. And secondly, you would want to choose someone lives near you or near where your assets are located. I think I already gave the example, like if the option in your mind lives in Toronto or New York, it probably wouldn't be available, or at least they become a burden to him because he had to constantly fly over to Calgary. That's not a good thing because it's not one-time thing. It's sometimes ongoing and could take a while. And you want to choose someone who is responsible and trustworthy. That's for sure. You don't want to, just randomly upon your neighbor, because like you never know, he could, do something harm to your estate. A good executor is always good to choose, like the person who are related to you. For example, your children or your older grandchildren, or spouse, or relatives, or close friends. Okay. if you don't have all those options, it's like I'm the only one here. I don't have anyone, and I don't have a friend. Sometimes the institutions could provide those kind of service. For example, the bank or trust company, but those not necessarily a good choice. And most importantly, you want to choose someone who is willing to take on the responsibility. You would like to, talk to them, ask them, hey, do you want to be my executor, like in the will? Like if they, because it's not a simple role. There are certain things they have to do.
Maybe more time.
So if they are not happy to, take on that work, then it's like no matter how reasonable or how trustworthy he or she is, he's not going to be a good option. Okay, so that, I mean, the executor would have to like identify the estate assets and liability, and he's also to administer and manage the estate and to satisfy the debts and the obligations of the estate, and to distribute and account for the administration of the estate. So it's a pretty, it's not a simple role.
Sally?
Yeah.
Sally? We have a question on chat. Do you want to answer now or later? I have a question.
Well, I cannot see it.
No, I can tell you the question. Do you want to do it now or later?
Either like, can you let me know the question?
First question is, do we have to pay the executor? Second question is, holding property the wrong way. What does it mean? I think it's in your notes. Holding property the wrong way. What does it mean?
Okay. Those are two questions, right? Yes. Now? Okay. So the first question, you can pay them. I mean, like, well, if it's your children or your spouse, you can also not pay them. But if it's a friend, I would like recommend to give them a reasonable fee. Of course, like all the disbursements, like he have to spend during the process, like there something like the executor have to done, and you would have to give him the budget to to deal with all the things, and you probably want to give him a not payment but compensation regarding the time he spent in doing this. I mean, if the executor you choose is your spouse or your children, that's a different story. Well, they can do anything for you. They don't ask for payment or compensation because you probably are leaving some of your estate to them. Mm-hmm. But if it's a good friend, you want them to be compensated at least like at a certain level, right?
What is that level?
Well, it depends. There's no set amount of, there's no minimum hourly rate or something like this. Okay. It depends on your situation and your relationship between the relationship between you and them, right? Well, because you know your situation best, you would know like likely what amount of compensation I can afford and he can like accept. Mm-hmm. You don't want to give, like if it's a good friend, you don't want to give them too much like it could result in a litigation between your beneficiary and the executor. Because let's say you appoint your good friend as an executor, and then your children as beneficiary, but you are leaving one of your property to the executor as a compensation, then the beneficiary could be unhappy, seeing that, well, his work does not worth that property.
Yeah.
I'm gonna sue him. Well, you don't want that, right? So reasonable.
Okay.
And holding property the wrong way. Well, I think it's better to give an example. So because it's comprehensive situation. Okay, so let's say you are holding, I mean, like, for example, like the property you are living in, both you and your spouse live in that property, but only your name is on the title. It's not such. Then you, in your will, you probably want to leave something to your spouse. Maybe most of the estate to your spouse. You want to make sure your spouse still have a secured and stable lifestyle. For example, continue to live in the house. You don't want them to move out of the house. Of course, like the dower right will give them the right to live in that property for their, like, nobody could force them to move out. But you want them to be secured in a more legitimate and less trouble way. So probably if you want, if you don't hate your spouse and you want to make sure they still live in the same kind of quality in the house, and don't have to worry about have to protect their legal rights by hiring a lawyer to defend their rights, then you probably want to adding his name in the property. I mean, holding the property as joint tenants, other than just having your name on title. Or like that another thing is if you and your spouse are holding the property in tenants in common, as tenants in common, then they only have half interest. Well, you probably want to consider that too. And like I know a lot of like Chinese parents, at least they just want to make things easier for their children regarding like the probate process. So they changed the property ownership to joint tenants between them and the children, so that their children would have the rights of survivorship, which means if let's say the mother and the son are on the title as joint tenants, so when the mother dies, the son will automatically become the owner of the property. The property won't form a part of the estate. So as soon as the mother dies, son become 100% owner of the property. If then it comes to a situation where if you also have a spouse who is not the biological father of that son, then there comes the conflict.
Well, mhm.
Well, it depends on the specific circumstance. But those are some examples.
Okay.
Okay.
So there are more questions in chat. You want to deal with them now or later?
I would say you try to deal with it as soon as possible, because they're always the best way to make arrangement, which is legitimate, according to the law.
No, I'm saying there are more questions in the chat. Do you want to deal with them now or later?
This lecture is until 11, right?
9:30, yeah. Because 11, yeah, we start the next one at 11, yes.
Oh, or 10:45. I think you told me there is an interest.
Yeah, 10:45, yeah, same.
Okay, so how about I quickly go through the topics and then I go back to the questions.
Sure. Okay, so we will keep the questions on the chat. Yeah. Sure.
Yeah. Okay, thanks. So, well, a bad executor, too old or too young, someone lives far away from you, not responsible, trustworthy, not particularly close to you. That means not good at representing your interests. You don't choose someone who hates you, because it happens. It's I trust my daughter, but my daughter actually have this huge history. Well, we're not necessarily have a good terms regarding the relationship. And then the good guardian, skip this one because I think probably it's pretty irrelevant to our audience. Okay. And who should I leave things to? Well, because I have a degree in China, so I know in China, the priority. I mean, there are certain people who are who have the same priority on the first class. It's your parents, your children, and your spouse. But here in Canada, if you don't have a will and you are married, and everything goes to your spouse. Spouse and common law partner are often top priority. Well, then your children is a priority too, but I would say second priority. And if you have, parents, siblings, niece or nephew, or disabled relatives, friends, you want to give some to them, you would want to have the wills done so that it could happen in such way, because otherwise they won't have a say in the probate process if you don't have a will. Or if you want to donate a certain amount of money to a charity or several charities, you would want to add that to your will. Of course, it's typically only a priority if you are single, or you don't have children, or you know that your children are self-sufficient, and you well, some clients consider the less I leave to my children, the better their future would be. then I want to, just, leave certain amount of my estate to like the breast cancer charity, like a research organization. That's great. That's fantastic. So what are the things you're going to leave to the beneficiary? So like those are the list of the things you are leaving to them. Shares of your estate. Probably you want, for example, if you have 3 children, you probably want to leave 1/3 share of your estate to each of them. Or you want to leave a particular item of your assets to one child. Let's say you still you have 3 children. Two of them are married, they have a family, they have a house, but like the youngest is single and does not have a property yet. So you probably want to, maybe you want to leave the house to dad, children, not necessarily the money. I mean, if you have like 500,000, you can give 250 to to each of the older children's, and then leave the property to them. I mean, it still have to be some kind of equalized, but maybe you have some special consideration. For example, do not want to sell the house because there are a lot of memories, or or it could be simply just let's say a car, vintage car, or any kind of car, or you have a set of furnitures, dining site. For example, you want to leave it to your nephew because he likes it, or to your grandchildren. You want them to keep them, and that dining table could just continues to be within the family. Well, you can do that, right? Trust for minor, we don't talk to okay, minor children not issue. Joint ownership, talk a little bit already. Life insurance. Well, life insurance, I don't know how many of you have life insurance. Life insurance, it won't form part of the estate, because no matter what you left to your beneficiary, the estate, the executor would have to pay all the debt. They would have to pay your tax, because like after death, you still have to pay tax. If you own somebody, like if you have some debts, they have to pay out the debts first before like they could distribute. I mean, they sell the property and distribute the money to your beneficiaries. But life insurance, life insurance don't if you owe somebody money, they cannot go after your life insurance. Your life insurance would be 100% goes to the beneficiary on the policy. So it's a good thing to have. Special considerations. Well, if you have children from a previous relationship, that's going to be a complicated issue. Consult with a lawyer. Well, regarding that, if you have ongoing support obligations, for example, spousal support or child support, If you own property in another country, like I said, you probably need another will in that jurisdiction. If you have disabled children, and do your closest relatives live outside of Canada? Kind of covered that topic already. Okay. When should you do your will? The first, like when maybe you can give this advice to your to your younger friends or your children when they get married or have or having their first child. That could be the good time to consider doing a will. Well, if you got divorced or separated, then definitely you want to revisit your will. And when your children become adults, certain provisions of the will will not, apply. For example, the guardian part. Or when the executor dies, because that's an important role in the will. You appointed like your good friend John, but he suddenly dies, then you definitely need to revisit your will. Make change to your will, because like then your will would have, you don't have that role. You states his name in the will, but he's not able to do that, and he cannot make any legal document saying, okay, I transfer my role of executor of such person's will to another person. You cannot do that. So you want to change your will, and you want to if you have a disabled family member, you want to make sure they have adequate support. Okay. Power of attorney, the second legal document. Remember, we said it's regarding the financial decision-making process, right? So most importantly, in this document, you appoint a financial representative. We call it attorney. So it's not a lawyer, but well, it's a financial representative to act for you if you become mentally incompetent. Here is what a good attorney is. Basically, similar considerations: not too old or too young, lives near you, responsible, trustworthy, willing to take on the responsibility. Want to talk about the timing of when this power of attorney becomes effective. Because a lot of clients, they know this is an important document, so they're doing it with me and signing it. But they all say, okay, after I sign this, can I, if I leave the country, let's say I went, I go to Mexico to have a vacation, and or like let's say Chinese New Year, I go to China to spend the Chinese New Year, and but I also have my property listed. I want to sell the property. Now I have this power of attorney. Can I have my attorney sign the the listing document for me? I don't have to be here. Can he sign the documents for me? So it's a difference between this kind of power of attorney and another another document, which we also do, which is not the enduring power of the attorney, but also a power of attorney, appoints attorney to sign the documents for you when you are not available. For example, you are going abroad, or like you simply just cannot sign the documents. Like especially during the COVID, it's so common because, for example, they want to sell the property in China, or let's say sell the property here in Calgary, but they are trapped in China because of the COVID restrictions. So in that situation, there's the document available, which is power of attorney. They can appoint their spouse or their children to sign a document for them so that they can buy a property, sell a property. They can do anything. But this power of attorney, and that power of attorney, most important difference between them is the effective date. The effective date of that power of attorney is when you sign the documents. When you sign the documents, the attorney can sign any documents for you, but there is the expiry date of that power of the attorney, because after the house is sold, you don't want that power to continue lies within that person anymore. But this enduring power of attorney, probably you sign it today, but you won't use it. I mean, like, this document won't come effective until 20 years from now, when you become mentally incompetent. So this is just like when you become mentally incompetent, this document become effective. So it's kind of like a will. Will is like, after you prepare the will, after you sign the will, it's just a paper lining in a safe or a deposit box, have no legal effect at all. And your beneficiaries cannot cash anything from it. But as long as, like, the moment that person dies, that will become effective. And this enduring power of attorney is similar. It's when you become mentally incompetent, this document come effective, right? But the thing is, you don't want to wait on that, because you cannot sign a enduring power of attorney after you become mentally incompetent, because you never know when you do need that. When you need that document, you won't be able to do that. So yeah, that's the trick. And personal directive. Personal directive is a document that indicates what your personal and medical wishes are in relation to a future situation in which you are mentally incompetent, like in a coma. The personal directive often specifies a personal representative who will make decisions for you, and also indicate what treatment you may or may not want. Well, this part talk about the medical decisions, but it's not just the medical decisions. Because like maybe for religious like reasons, some people does not want blood transmission, then they would want to have that in the personal directive, telling the doctor, no, you cannot give me blood transmission, or some people, they just feel like at the end of their life, they just don't want to have all those aggressive medical treatment. like the tubes, the life supporting system, just like living like a vegetable for 2 years or 3 years. That's not something they want. Then they want to put it in a personal directive. Personal directive, well, some care facilities will ask their residents to have personal directive. When you have a personal directive, you should give a copy to your family physician. And the doctors would follow the representative, or if you call them agent, follow their instructions regarding the medical treatment. If there's no agent or no personal directive, then the doctor doesn't have clear instructions, right? They could probably want to contact your relatives, but your relatives does not know your intention or the way you want things to be. And also sometimes in hospital, it's like time is of its essence. Personal matter, like this personal directive is a document deal with your personal matters, but how to define like what things counts as personal matters. We talked about the medical, so which is health care matters. Also accommodations. Some people maybe do not want to live in a nurse, like maybe they want to continue to live in their house as long as possible. Like regarding the accommodations, they don't want to move to another city. If they don't have personal directive, then they're if they have the personal directive, then their representative would know their wish. Because like when you become mentally incompetent, you cannot telling people what you want, right? And who do social with, and the legal matters, participations in social, educational, employment activities, and like anything not a financial nature. So basically, personal in your power of attorney, financial matters, personal directive, all the other matters, which is not a financial nature.
Xiaoli?
So, yeah.
Do we want to take a break here for questions? We may not have enough.
Yeah. So basically, this is my the stuff I want to talk today. And let's go back to the questions. But where can I see the questions?
I'll read the question to you.
Okay, thanks.
The person who inherits the house, do they have to pay tax on the appreciation value of the property?
Okay. So, if you leave the house, I mean, these questions I actually should not answer because, like, I should suggest you to go to your accountant for this kind of tax consequence of anything, because I'm a lawyer, not an accountant. So, but I'll just give you some information regarding if you leave one property to your spouse. Let's say you are not joint tenants. It's just a totally different property. He has never lived in. Then, because he's a spouse, he does not have to pay the capital gain tax after you die. But he can defer this amount, roll over this amount, like to when he died. When he died, he also have to pay tax, right? He will pay that amount when he died. I mean, his executor will pay that amount. But if you leave the thing to your children or to your friend, he would have to pay the capital gain tax. Okay. So it's good to leave it to your spouse because you can defer a certain type of tax. Don't have to pay it right away. But anything related to the tax, you would want to consult accountant.
Mm-hmm. Yeah. The next question is about living trust. I don't think we can cover that today. So the question is, will you be speaking about living trust, and can you speak about trust companies? Maybe that's another topic.
Trust, it's complicated
yeah.
issue. Well, it provides certain security, but also it takes time and money to set a trust, and you have to meet a lot of requirements, and also tax consequences you have to consider. If you don't well, like we can talk about that like in another situation, because like there's some basic like definitions and conceptions like we have to go over them before we can talk about a different range of the knowledge.
Yeah, maybe we need to invite an estate accountant to talk to everyone about those questions.
Yeah, that's a good idea.
So the next question is, can an executor be more than one person?
Okay. So the executor, so you're talking about the wills. Well, you can have multiple executors, but I won't necessarily suggest doing so because you're creating conflict between the executors, and you are introducing uncertainty to the process, because let's say two executors, who's gonna make the final decision if there's disagreements? Well, I understand where this question come from. For example, like I have this kind of question rising up because they have, let's say, two children. So they want to appoint both of them as executor. They don't want one of them to be felt left alone, or like you favor one child, or you trust one, not the other one. Well, the way to resolve this is, you can you can have multiple executor, but not in the same rank. I mean, like the first choice is your oldest child, and if he or she cannot or is not willing to take on that role, let's say cannot maybe means like by the time of somebody like the parent death, the first one moved to another country, or is on business trip for one year, cannot come back, not available, then you would have a second option. In that situation, you would say in a way like that situation, I will have a second option of my second second child to be my executor, but you don't want to name them both like executors, and then they won't know, like, because there are always disagreements when it comes to probate or the role of executor. You don't want them to argue, go into arguments and goes to court to decide who should make the final decision. Judge will make the final decision.
Related to this, is there this scenario, for example, I will not make any of my children be the executors because, yeah, for the reason that you stated, right? But I would make a good friend to do that. Is there an option to do a primary executor and a secondary executor, just in case something happens to the primary executor?
Oh, yeah, it's recommended. I always have like alternate like options for the executor.
Okay.
And like, yeah.
Okay.
Like second option, even a third option, so that your will could be more stable in a way that something changed to your first choice executor. You still have the second one, a second option, so you don't have to change your will. And if something happened to your second option, you still have a third.
Yeah.
You still have a third option, so you don't have to change it. But like if you don't have a second choice, then if something happened to your first option, then you would have to redo your will, right?
Yeah. Okay, the next question here. Can you make a stipulation that the spouse stays in the home for their lifetime? And with joint tenants, then it is passed down. I'm not sure if you understand that. If not, Lori, can you explain?
Yes, please.
Lori, are you still here? I have opened everybody's mic already. Feel free to ask questions. Maybe she's not here anymore. Okay. No, she's here, but she's not responding. 大家有問題冇 ？Do you have any questions？ 你哋個麥我幫你開咗㗎啦。
OK。
我想問，可唔可以講廣東話問啊？
你講，我幫你翻譯。
好啊。
如果譬如你間 house 係你同 husband 嘅，如果一個 pass away， 咁另外嗰個留低係佢啦，嗰間 house 淨係留翻俾譬如淨俾個 wife 咁wife 個 land title 係咪要 change 咧
？So if the husband
Yeah, if the husband passed away, the house is on both husband and wife's name, right?
Yeah.
One passed away, and then the name title, do you need to change?
No, but the wife is originally in the title, right?
Yes.
Yeah. So yeah, Sally, you can answer that.
Yeah. Yeah. You can change them through Untitled Office. It's a really minor procedure to go. You just fill out application.
Do you need to change or no?
Well, if you continue lives in that property, like you can like keep it the way it is. But if you want to sell the property, you want to like eventually you will have to make the change, right?
Okay.
Yeah. And it's not difficult at all, so don't worry about it.
That means she doesn't need to do anything until she wants to sell the house or she wants to leave the house or that kind of thing, right?
Well, I would recommend to make the change. Like the things, like something could happen to the surviving wife too. Like all those kind of things, you want to do it in ahead of time to avoid uncertainty. Of course, the legal status, you like the surviving wife 100% own the property, right?
Yeah.
That's the legal status. You want to that to be shown on the documents too, so that won't trouble other people when it comes to the transactions or when they have to produce some documents. Because like ordinary people, they will look at the deeds. I mean, look at the certificate, not looking at the real situation. A lawyer will tell you, okay, even though your late husband's name is still on title, but you are the surviving wife, so I know you are the owner. But the buyer wouldn't necessarily know. And if you sell the house, you would have to make the change by then. Okay. And you have other things to do. If you have to move, you have to clean out the house. A lot of things you have to take care of. Why not do it before when you are, not dealing a lot of things?
Okay. Would it be the easiest way is just go to land title office to remove the husband's name and produce the death certificate? Then you could change, just remove his name from the title.
Yeah, you just remove the name from the title.
Yeah, that will be the easiest way.
Yeah, easier for you to renew the mortgage if there's a mortgage.
Great suggestion.
And if you want to refinance also, right?
Yeah, thank you.
Well, it's just a procedure.
Let's take one more question. Any more questions? Because
here's Judy. I do have one because just now we're talking about the change of the title. My question is, at that point in time, can we ask to reevaluate the value of the property? The reason being then, let's say we have been living in the house for 30 years, right? The price has gone up a lot now. Mm-hmm. So, in case after I change the title, I die, and then my son inherited it, they would have to pay for the capital gain for the property, right? If at that point I readjust the value of the property, would it help?
Is that a tax question or a legal question, Sally?
Yeah, maybe we can wait till the next question. I'm just wondering, when you are changing title, can you also reevaluate, price of the property?
Well, I don't think you can decide the value of the property. It's like when you're making
appraiser, we can do it for you, right? And then you filed it. So
yeah, well, that can be done, but it comes with a fee. And
because what you said earlier, if we leave the house later on to the son and not the spouse per se, and they would have to pay for the capital gain of the house. Okay. Thank you. Well, we have to wait for the accountant.
Parents always, think very long for their children. They just want to pay everything for their children, and just.
I think it's the culture.
So, may I ask the power attorney and personal directive? Is it have to have a lawyer to do that too? Or you can download the form online and do it?
Well, how can I answer? I would have to say I would suggest you to go through a lawyer, because the law is constantly changing, and there are some requirements regarding like how the document should be drafted. Well, like I have seen some templates like downloaded like online. It did not reflect the current like changing of the law. It's a commercial thing, and they won't, like, if a lawyer does the legal documents for you, let's say power of attorney or personal directive, the lawyer would have to assume the liability. So he will make sure it's 100% accurate in law and suitable for your situation.
而家提問題嘅，你問佢。